Okay, let me do a super awkward introduction. I haven't done a video in like a month. I have to remember how. Hey everybody, and welcome back to Life as a Law Student. Today, I've convinced my two coworkers at the Kane County State's Attorney's Office to join me. We're gonna play a bar exam game because none of us know what we're doing and thought that would be a good idea. Do you want to introduce yourselves?
Sure. Hi, I'm Michelle. I'm an Assistant State's Attorney at Kane County State's Attorney's Office.
Yeah, my name is Susan, and I am also an Assistant State's Attorney at Kane County State's Attorney's Office.
So I just got my Barbary books for bar prep in the mail like a week or two ago, and one of them is the simulated MBE. So I thought we could just scroll through this and ask random questions and see how we do.
Okay. Do it. Let's just open up a random page. I'm ready.
Okay, do you want to pick a number page?
69.
Okay. Oh, that's a long freaking question. Alright, here we go.
Oh gosh.
This is like a whole page long question. A state statute has adopted the common law definition of larceny. Another statute provided as follows. It shall be an affirmative defense to a crime if the defendant establishes by clear and convincing evidence that due to a mental disease or defect he was unable to appreciate the criminality of his conduct or conform his conduct to the requirements of law. A homeowner was leaving town for 2 weeks, and he asked his neighbor to stop by the house each day and water the plants. While at the homeowner's home, the neighbor found the keys to the homeowner's new car. The neighbor took the car and drove it into town to show his friends. The neighbor told all his friends that he'd purchased the car. Homeowner returned home 3 days early, saw that the car was missing, called the police. Later that day, neighbor was arrested and charged with larceny. At the neighbor's trial, the neighbor testified that he intended to return the car, and 2 psychiatrists testified that due to a mental defect, the neighbor suffered from an extreme inferiority complex and delusions of grandeur. So, like, all of our defendants. The doctors further testified that his mental condition caused him to take the car and to tell other people he owned it. At the conclusion of the evidence, the court's instructions to the jury included the following. 1, if you find by preponderance of the evidence that the defendant intended to return the car, you should find the defendant not guilty. 2, if you find by a preponderance of the evidence that due to a mental disease or defect, the defendant was unable to appreciate the criminality of his conduct or conform his conduct to the requirements of law, you should find the defendant not guilty. The neighbor was found guilty, and he appealed, claiming that the jury instructions violated his constitutional rights. How should the appellate court rule? A, both instructions were constitutional.
I did not expect.
It became civil law and constitutional law. B, both instructions were unconstitutional. C, instruction 1 was unconstitutional and 2 was constitutional. And D, vice versa, instruction 1 was constitutional, instruction 2 was unconstitutional.
I know that you have to intend to deprive the person of it, like, forever.
Forever.
Forever?
I think so, yeah. Common law definitions of crimes are really weird. Like,
What
one
is
of them,
it?
like, breaking and entering, whatever it's called.
Burglary?
Yeah. That one, like, you have to, like, in common law, it had to happen at night.
Yeah.
Yeah. It had to happen
But
at
you
night.
have to remember that the MBE questions is literally whatever information they give you in the question. So what was the common law definition of larceny again, or whatever?
It's
it
not
was?
in- it's not in there.
It
You're
says
supposed
they
to know it.
adopted the common law definition and another statute.
My general first thought is that this one is unconstitutional because it places the burden of proving not guilty on the defendant, which you can't do.
For those of you at home, this one was the first one.
Yeah, it's the one if you find by a preponderance of the evidence that the defendant intended to return the car, you should find the defendant not guilty. I think, like, I generally think that's unconstitutional because you're placing that, like, the state has to prove all of the elements beyond a reasonable doubt. You don't have to you can't put that burden. I think this one might be okay because affirmative defenses, I think affirmative second one has to be. I don't know for sure though, because I think affirmative defenses, like, the defendant has the burden of proving that. Yeah.
Yeah.
Yeah. Okay.
Yeah.
So what's the answer?
So
I think
1 is
that-
unconstitutional.
I think this one, I think it's C.
Is that what you
See,
said?
1 is unconstitutional and 2 is constitutional.
Yeah.
That's
You
right.
were right. Burden of proof.
Burden of proof.
Apparently it is criminal law and procedure, but I was just confused by the preponderance of the evidence thing.
Because that's
That's not the
That's
burden of
not
proof
very
for criminal.
yeah.
Well, I mean, I guess, like, if you're putting it on the defendant, like, they don't have to prove beyond a reasonable doubt that they're not, like,
The affirmative
the
defense
affirmative
is
defense.
preponderance.
The affirmative defense, I think, is preponderance because that will create a reasonable doubt then
Yeah.
to their guilty.
That makes sense. Okay, Susan, you're going to read one.
Okay. What number?
47.
This is a shorter question.
A,
Great. Love that for us.
An employee filed an employment discrimination action against her employer in federal district court. I better get this answer right or I'm going to be upset.
It's a criminal procedure, or a civil procedure.
Yeah. I didn't learn that. I had that class during the shutdown. I learned nothing.
I had it in person and I learned nothing.
You might know it though. The employee alleges that she has not been promoted because of her gender. She intends to call a coworker as a witness at trial. The coworker will testify that a senior manager of the employer told the coworker that the employee would not be promoted because the employer deemed women to be poor managers. Is the identity of the coworker subject to discovery by the employer? A, yes, the employee must disclose the identity of the coworker, but only if the employer asks for the information in appropriate discovery requests. B, yes, the employee must disclose the identity of the coworker, but only as a pretrial disclosure 30 days before trial. C, yes, the employee must disclose the identity of the coworker even without any requests from the employer. Or D, no, the coworker's identity and her testimony consists of trial preparation materials and are subject to qualified immunity from discovery. That answer just makes no sense.
I feel like it's A or B, but I don't know why.
Oh my gosh.
I'm very bad at civil procedure, but
It's probably the discovery.
my guess is C.
Oh, really?
I'm trying to remember the federal civil procedure rules. There's like certain things that are just automatically discoverable, no matter like when the suit starts.
It or not.
Yeah, so there's like I know expert witnesses are always discoverable. I think. I don't know. Susan, anybody?
You have to disclose all witnesses you intend to call at trial.
Really?
Yes.
So which one is it?
So it's I hate these.
Which one do you think it is, based on that?
This was her job.
Susan and I started on the exact same day, and so it's been really fun as an intern versus an attorney of 5 years to know exactly the same amount of information.
It is very interesting. No, I think it's... I'm thinking like practice as opposed to the like actual question. Because you have to disclose witnesses. I think you're required to do it 30 days before. It typically happens way before that.
I think it's C, or I think it's the 30-day pre-trial disclosure. Yeah.
Yeah. It's C.
Hey.
Must disclose the identity of the coworker even without any request.
No, you didn't get it right.
Yes.
I'm not gonna pass this exam.
Yes, you haven't even started studying. Like that. The only thing that matters on the bar exam is what you studied for the bar exam. Do not take into account anything
you've learned in practice, because it's not the same.
Well, it's even the same thing like with the statutes that are supposed to govern our procedure at like in traffic court. Like when we were talking about the motions for continuances and stuff, that after like the first setting, basically they're supposed to all be written, and that has never happened in the history of ever.
Because it's like practicality. Like we can't do that. Like there's not.
Yeah.
There's no.
Yeah.
We don't have time to do that. All right. An owner purchased a parcel of property adjoining a 5-foot wide strip, which was a private right-of-way. Unsure where the exact boundaries of her property were located, the owner planted a garden on the 5-foot right-of-way strip and enclosed it with a wire fence 2 weeks after taking up occupancy.
Can't do that.
The owner maintained the fence and garden for 20 years. I think we're talking about adverse possession here.
We are.
You know? At which time she removed the fence and smoothed out the ground where the garden had been located. 5 years later, the owner entered into a written contract to sell the property to a buyer. The description in the contract included the 5-foot strip. After research in the county recorder's office, the buyer discovered that the strip was a private right-of-way when the owner purchased the property. After properly notifying the owner of the problem prior to closing, the buyer refused to tender the purchase money to the owner when the closing day arrived. The owner sued the buyer for specific performance.
Oh my god.
This turned into a contract question instead of a...
I hate that. I do remember that about the bar. You're like, oh, I see where this is. Nope, sharp turn.
Well, that was the criminal law one, too. I was like, oh, criminal law, we're good. And then it was constitutional, and I was like, oh, good lord.
Sharp turn.
The owner sued the buyer for specific performance of the real estate sales contract. His jurisdiction's statutory adverse possession period is 15 years. Who will prevail? A, the buyer, because the owner failed to provide a marketable title. That is a thing. B, the buyer, because the owner surrendered her adverse possession rights when she removed the fence, as her possession was no longer open, notorious, and continuous. The buyer, because one may not adversely possess a right-of-way. D, the owner, because she held the right of way for a longer time than the minimum required by the state adverse possession statute. Not B?
Not B.
Not B.
Nah,
No.
I agree. I don't think it's C either. I don't remember hearing anything about, like, you just categorically can't adversely possess a right of way.
Yeah, I've never heard that either.
Okay, I think it's whether she owned it or not, because if she owned it through adverse possession, then it would be marketable title.
Right.
Because then you have it, and then you can't just back out of the contract.
But yeah, adverse possession doesn't stop if you change whatever it is into something else. That's not my understanding.
Plus, it was up for 20
continuous,
years. It was up for 20 years,
Yeah.
and the adverse possession period is 15 years.
So are we saying it's D?
If that's enough to do adverse possession, then I think the owner wins.
Right, because adverse possession is the whole. It even says here it's like the open, notorious, continuous.
Don't you also have to give notice or something though?
As long as it's What do you mean notice? Like about adverse? possession?
Yeah.
As long as it's
open and
open.
notorious, that's kind of the notice aspect of
yeah.
adverse possession.
That I do remember.
Oh.
Yeah, because then like if the person were to show up and see like the fence on it, they would be like,
Hey, that's mine.
I didn't
Yeah.
I didn't make that fence. Like
Yeah.
Yeah, and I don't think the fact that you take the fence
Down makes any
after,
difference.
like once you own it, you own it. You don't lose the ownership because you lost.
right, because you like changed what was on
Yeah, after the adverse possession happened.
Watch us be wrong. That was a
Are
very
we-
thoughtful
I think we're saying
process,
D.
but
Are we thinking D?
I think so.
Want to be A? Oh no.
It's A.
Oh,
So
no.
it was between the two that we had come to.
Okay.
At
That
least
makes
our
me feel
process
better.
of elimination was good.
That
Yeah,
makes
so
me
the
feel
owner
better.
failed to provide a
Marketable title.
Wait, maybe go to the explanation
Yeah,
for this
I'm
one.
going
I'm
to.
kind of curious. You don't have to
Property
read
law.
it word for word. Just explain it to
Alright,
me.
well, give me a second.
Property law was my least favorite subject in law school and to study
property
for.
is-
I had a really good professor
Oh, I did too.
who was
mine
visiting
was trash.
from Chicago, Kent, and we begged WashU to hire him, and they didn't, and we were very sad.
Alright, it says very quickly, I'll explain why D is wrong.
Okay.
Well, D is wrong because, as discussed above, the
D
fact,
is wrong because A is right.
the fact that the owner has title to the strip does not mean that she has marketable title. So she did. Okay, so we were right about the adverse possession.
I just
She-
don't know what
Marketable
title is.
All right, absent a judgment in an action to quiet title or other tangible proof that title to the 5-foot strip has actually been acquired, most jurisdictions would not consider the owner's title marketable. It's
You need
because it's
something
still in
writing.
question.
You need something in
Officialized.
writing.
Right, because like somebody could come, like that person could come in and then challenge it, so it's not marketable.
I feel like as lawyers we should know that everything has to be in writing.
Even though what we do in the branch courts is most of the time not in writing, and not on a record.
And not, for the record, Judge.
I'm objecting for the
I'm
record.
objecting for the record.
Which
For the
doesn't
record.
exist.
Doesn't exist.
Oh my gosh, Michelle. I can't wait for you to hear this question. A homeowner who regularly borrowed garden tools from his neighbor went to the neighbor's house to borrow the neighbor's...
Oh my goodness! My question is, was there a battery?
We have a case right now that's Michelle's bane of her existence.
It's a restitution hearing, and the whole argument is a leaf blower.
Whether a battery was in it.
It's wild.
Anyway, she tried to send me to the store to buy the leaf blower, and I would not go. The neighbor was not at home, but the leaf blower was in his unlocked garage with his other garden tools, so the homeowner took it. Unbeknownst to the homeowner, the neighbor had drained the oil from the leaf blower's motor. The homeowner ran the leaf blower for an hour. Motor was totally destroyed because no oil. The value of the leaf blower at the time that the homeowner took it was $300. An identical one cost $500. The cost of repairing the motor is $150. A new motor will cost $250. The neighbor sues the homeowner on theory of conversion and is successful. What damages can he recover? A, $300, which was the value of the leaf blower, but the homeowner will keep the leaf blower. B, $500, which is the cost of a new leaf blower, and the homeowner will keep the old broken one, I guess. C, $150, which is the cost of repairing the motor, and D, $250, the cost of a new motor.
Was that the fair market value at the time?
Yeah, I think so.
It's 500. Yeah. I'm like 90% sure it's the fair market value
Isn't it
at
fair
the time.
market value, like, for that one that he took, though?
Yeah.
So that's
For
not
one-
500. It was be 3. Like it depreciates in value over time, right?
Cost of repairing the
So I
motor.
think you only get the 300.
Aren't you just supposed to like make the person whole?
But and then they didn't say that the leaf blower was destroyed, just the motor was destroyed. So I
they just
feel
follow
like
the
maybe
motor?
150.
Yeah, because
To
you're supposed to
repair
you're
the
supposed to
motor?
put the person in the position they would have been had it not been
Yeah,
damaged.
because you don't
Right.
want
So
to
it'd be
like
the
give them
motor.
more. Like,
Yeah.
I
would
think
say-
it's 150, the cost of repairing the motor.
I also think so, but I also think
Okay.
that would be wrong.
Eh.
Well, because if you're putting someone in a better position than they were in,
It's
that defeats
unjust
the purpose.
enrichment.
Yeah.
I'm pretty sure that's
A.
contract's term.
Torts 300, and the homeowner gets to keep the leaf blower.
So fair market value of whatever. it
But
was
why?
at the time it was
Why isn't it
broken.
just the cost of the motor, which is what he broke? He didn't break the leaf blower.
Wait, is this a torts question?
Yeah,
Yeah.
it is, which was my least favorite class. Damages based on the cost of the repair of the motor are more appropriate as a measure of actual damages for trespass to chattels action. For interference with a chattel that is so serious to constitute a conversion, the damage remedy is different.
Converge. Oh, okay. That makes
Oh,
sense.
so it's that
It's trespass to chattel over conversion. Conversion is a more serious.
So what's trespass to chattels versus conversion?
It has to do with
The
like the degree of possession you take over the item.
it's that you're depriving the owner of the use of the chattel, essentially. So like you're trespassing in the sense that you were depriving them of their own chattel.
But this was
But then when you go so
Conversion
far
is
as
when you
you
go
damage
far
it.
enough to like basically deprive them permanently of the possession because he broke it.
It broke the motor.
Yeah, but the leaf blower doesn't work
Hold,
without
please.
the motor. Are we good?
Hello?
We are on film.
I'm good. How are you?
What's
Talking to some
happening?
random.
A few moments later.
Oh, it goes all the way to
101.
200. Ooh. All right.
But not if it's long. If it's long, then pick one of the ones around it that's short.
Oh, it's very short.
Okay.
Ooh, it's an appeals question.
Uh-oh.
Oh God, I'm sorry, guys.
What is with you in employment law?
It's literally class action federal law.
No, I hate class
Wait,
action.
I've been watching Goliath, and it's all about class actions. So
All right.
you all know.
A group of employees brought a class action lawsuit in federal court against their employer, alleging employment discrimination and the violation of several labor laws. The court granted certification of the class. Wanting to force each employee to litigate individually, the employer immediately files an appeal. Can the Court of Appeals hear this appeal? A,
Interlocutory.
yes, because all trial court orders are reviewable on appeal.
False.
Did you see my face? I was like, yes, because all trial court orders are reviewable on appeal. Yes, because an order granting certification of class action is immediately appealable. C, no, because only final orders are reviewable on appeal. That is false.
That's the general rule, but there are
Interlocutory appeals.
interlocutor appeals that are the exception.
D, no, because employees' legal claims are still outstanding.
We think it's B.
We think it's B. Because you can have, it's literally what Michelle said, it's called an interlocutory appeal.
Yeah.
There are certain things you can appeal immediately, even if it's not like the final, whatever. We are correct.
Yeah! I did nothing.
A+. What number?
$32.
Okay, if it's something having to do with the rule of perpetuities, I'm out.
365
Oh,
times
we
5.
got a hearsay.
Oh, wait, I like hearsay.
Alright.
Something that nobody has ever said.
No, hearsay is horrible. Unless it's easy.
It's
Unless
horrible
it's statements
unless
of an
it's not.
opponent, a party opponent, then I'm like, welcome.
Or
That's
what's,
just not
what's
hearsay.
what's the legal term for like an exclamation?
Excited utterance.
Excited utterance. Exclamation.
An exclamation,
I like
Your Honor.
present sense impression.
Present sense impression.
That's a good one.
All right, I'm
I
ready.
don't have many feelings about.
Please hold.
It was aggressive.
My
ringtone.
mom. It actually, that's not even my normal ringtone. Normally it sings Agony from Into the Woods.
That's more aggressive. A plaintiff plaintiff is suing her former physician for slander based on statements allegedly made by the physician to the plaintiff's co-worker that the plaintiff had difficulty conceiving children as a result of her history with venereal disease.
Okay.
jeez.
Drama.
I don't think this is slander so far.
I don't think that's the question.
Just saying, I don't think it is.
The physician denies making any statements about the plaintiff. During the trial, the plaintiff calls as a witness her neighbor to testify that during her last visit to the physician's office, the physician told the neighbor that she was angry with the plaintiff for posting a negative review of her medical practice on a popular website, and that she made sure to even the score by sharing with others some opinions about the plaintiff. The physician objected to the testimony. How should the court rule on admissibility of the statement?
Wait, the physician is a civil case?
Yeah.
And the neighbor said that the physician said.
So the physician's the defendant, and so the neighbor say, I think it's exception. It's not hearsay.
Wait, say the statement again?
During the trial, the plaintiff calls as a witness her neighbor to testify that during her last visit to the physician's office, the physician told the neighbor
Got it.
that she was angry with the plaintiff for posting a negative review of her medical practice on a popular website,
So,
and that she made sure to even the score by
So
sharing.
not
So it's
hearsay.
not hearsay.
It's not hearsay.
So
exclusion.
so the four options is testing whether you know the
Whether
difference
it's an
between not
exclusion or
hearsay
an
or
exception.
exception.
Although I have to say, I think that's a stupid rule. I think it is an meaning of the words, it should be
Exception
an
and
exception.
exclusion.
A, admissible as an exception to the hearsay
Nope.
rule. B, admissible non-hearsay. Inadmissible because of the physician-patient privilege. Oh.
No.
No, because she's talking
She's
to
the
the
one-
neighbor
yeah.
about, well, she's still talking
The
about.
neighbor's the one testifying about what the doctor said to the neighbor.
Yeah, so
So-
hearsay
So the
would be the
patient
first
holds
issue.
the patient holds the privilege,
Yeah.
right? Inadmissible hearsay not within any exception, so we think B.
B.
Yeah.
I feel confident. B.
No, that's when they'll get you.
That's how I got my voice. Actually, that is a bar prep trick that I feel like really helped was
It's B!
don't read the question first. Browse the answers so you know what it is, because they will.
That'll help you because then you'll know what the type of question
Because
it
then
is.
you'll be like,
Yeah.
oh, they're asking, is it constitutional? So then you don't start reading something and go, larceny. Oh, it's a criminal law question. Because they do that on literally every single one, especially the long questions.
Yeah.
Read the answers first.
We did it.
We did it! We didn't do terribly. I didn't keep track of how many we got.
I didn't either.
I
I'll
think
put
we
the
got,
score
like,
on the
1 or 2
screen.
wrong, right?
It has to be like 1 or 2 wrong.
Yeah. I think we got at
think we got-
least 4 out of 6,
Yeah.
which is mostly passing.
Yeah.
I think that's like
That is passing in the bar world.
Passing
yeah,
is passing.
it's like 60% or something. It's like what you gotta get.
Good job, team.
You passed the bar.
I would fail the bar if I took it today. Let's be real.
Well, yeah.
Do you guys have any takeaways for viewers of this video regarding the bar exam?
Mostly what I said already is that forget everything that you think you know.
Or anything you learned in practice.
Yes. Because
Forget it.
it will not. It probably won't, and it'll just confuse you. So don't try to rationalize anything that's happening when you're studying, because it won't make sense.
Yeah, don't try to be like, oh, I remember from this that it's that when you're doing the question.
You're wrong.
You're wrong. You're 100% wrong. And
Learn-
don't ever use anything you learned from me or Michelle on the bar exam.
Truly! But anyways, you'll be fine.
Yes.
And you'll retain a lot more than you think you will.
Agreed.
It'll feel like your brain is exploding while you're studying, and there'll be times where you literally need to just walk away from it for a while to let your brain relax. Don't feel guilty about that. But you'll be okay.
Well, thanks for being in the video, and thank you guys for watching. I'll see you next week, and actually probably not. I'll see you eventually, and until then,
She's gonna be in an escape room with us next week.
until then, God bless. Bye. Okay.
Is this recording?
Mm-hmm.
Oh. Can you hear me?